All right, good afternoon, everybody. It's Ben Thompson here. I'm the CEO and co-founder of Employment Hero, and we are conducting our end of financial year employment law update. There's been a lot of changes over the last few months in the whole new government. So we're very excited to be able to give you all an update on the things that we're seeing changing and hopefully help you stay ahead of the game. I'm joined today by Simon Obee, who is the principal lawyer at EI Legal and general counsel and head of professional services at Employment Innovations. Welcome, Simon.
Hi, Ben. Hi, everyone.
Great to have you involved today, Simon. I know how much value everybody gets from you attending our webinars, so really appreciate you giving us your time and expertise. As this is a live Q&A session, we'll keep the Q&A box open. It's down in the bottom right-hand side of your screen. So as Simon is talking to particular points, feel free to throw questions into the Q&A box. We'll try and get to them in real time, but we'll also have a Q&A section at the end where we will sort of come back and try and address the most commonly asked questions. So yeah, do feel free to throw questions into that box and we'll get to as many as possible throughout the entire event. Also, we've got a lot to cover, so we'll probably move through it quickly if we don't stop for your questions. Again, we'll have a copy of this recorded. You'll be able to watch the recording. We'll be sharing that with everybody. And there'll be a survey at the end of the webinar just to get your feedback on how we can deliver more value and what you thought of the event. Just a little bit of housekeeping, if we can jump forward a slide. We have a legal disclaimer. This is not legal advice. Simon is attending to provide his views, but not advice. If you do require particular legal advice, you can engage Simon directly or his team of lawyers. And if you do need particular advice, yeah, consult an expert. But that's enough of that. Next slide. Just want to quickly give you an overview of what we'll be covering. So minimum wage increases. We had the national minimum wage case announced, the decision announced last week. So Simon will be giving us an update on that. Changes to superannuation, end of financial year payroll obligations, a review of employment law changes over the last financial year, and some of the changes that are likely to occur with the change of government and how that may impact employers. With that, I think I'll hand over to Simon to get us into the first topic, which is the minimum wage increase. So thank you, Simon.
Thanks, Ben. Okay, so as Ben said, we had the minimum wage increase announcement last week, and it was a bit of, I guess, an unprecedented way that it's been approached this year. Usually, for as long as I can remember anyway, there is one increase for everyone, whether it's an award-covered employee or an award-free employee. This year we've had two different rates of increase depending on whether an employee is award-covered or not. The other thing that's new is that the increases in certain circumstances refer to a dollar amount rather than a percent increase, and you'll see what I mean when I go through it. So that's new. And then, as we've had for the last couple of years through COVID, there is a staggered date for when the increases come into effect. For most businesses, it's going to be the 1st of July, but for some, it's the 1st of October. So I just say that by way of an introduction, just to highlight that this year things are being done a bit differently, so make sure you don't get caught out by that. So looking at the details, the national minimum wage, which is the minimum wage for employees who aren't covered by a modern award, from the 1st of July, it's going to go up to $812.60 per week. That's based on a full-time employee doing a 38-hour week. and that translates to a minimum hourly rate of $21.38, and that's up from $772.60 per week or $20.33 per hour. And that amounts to an increase of $40 per week or 5.2%. So that's the situation for award-free employees. For award-covered employees, it's different and it's a little more complex. What will happen for employees under awards is that the minimum weekly wage will increase by 4.6%, but that will be subject to a minimum increase of $40 per week, based on a 38-hour week. So what that will mean in practical terms is if the current minimum weekly wage in an award is $869.60 per week or less, there will be a $40 increase. And if the current minimum wage is at least that amount, then there'll be a 4.6% increase. And obviously, when we're looking at casuals, there will be a 25% loading on top of those hourly rates. So as I say, it's a bit more complex than usual. So make sure you're across those changes. The Fair Work Commission and the Fair Work Ombudsman are publishing updates to the awards and pay guides, so they should be in place in the next week, I should think. The other thing are you jumping in, Ben?
Oh yeah, just a question from Hamish Coffey, if you don't mind me mentioning your name, Hamish. Will the minimum increase of $40 a week apply to trainees, i.e. not adult award classifications? I guess juniors as well. How does it flow through to juniors as well as trainers?
That $40 is for adult classifications. The $40 minimum won't apply to trainees or juniors. They will be paid a percentage of the adult increase, but the $40 is just for adults, absolutely. But yeah, great question, Hamish. Okay, so hopefully that's clear enough. The second thing, of course, which is very important, is what date does the increase come into effect? For the vast majority of employees, it's going to be the 1st of July. That is the case for all award-free employees. But as with previous years, as I said when introducing this, for those industries judged to be most affected by COVID, there is a later introduction date. So for the employees covered by the awards on your screen in hospitality, aviation and tourism sectors, the increase will be the 1st of October. The Hospo Industry Award, the Registered and Licensed Clubs Award and the Restaurant Industry Award, I'm sure will apply to many of the people watching. So be aware of that, and as of course as well aviation and tourism. Okay, so just to finish off on this topic, just a couple of top tips. It's an obvious point really, but so much of Australian employment rules and regulations, and in particular the minimum wages, are impacted by the modern award that applies to an employee. Remember, there can be more than one award that applies to your business, and the majority of employees in Australia, particularly the lower paid employees, are covered by an award. So if you're not sure about award coverage, if you've taken the position that awards don't apply to your business, I think it's always a good time when these decisions come out, just to make sure that you've understood your obligations. If you need any help understanding which awards might apply, do reach out to Employment Innovations. It's what we advise on all day, every day. The second point there is a question that always gets asked when the increase gets announced. How does this apply to employees being paid over the award or above the award payments or above the national minimum wage. How do these increases impact them? So the minimum wage is just a minimum. If you are paying your employees above those rates, there is no general obligation to make an increase. The caveat to that, I suppose, is if you have set your wages slightly above the current minimum wages, it could be that the increase will tip over what you're currently paying, and so there may be an obligation to make some sort of increase. The real danger here, I suppose, is for employees paid a salary, particularly employees covered by a modern award. It's very easy to come unstuck here, to set a salary that you think is going to be sufficient, but there are so many entitlements for employees under awards, overtime, penalty rates, allowances, annual leave loading. It's very easy for what seemed like a very generous salary to perhaps not meet all those entitlements, particularly if you have employees who are doing a few extra hours. Remember, overtime can be at double time or even double time and a half in some circumstances. And then the final point there, how does this affect employees covered by an enterprise agreement? If you have an enterprise agreement in place, the Fair Work Act says that the base rate of pay that you pay to an enterprise agreement employee, that is their rate of pay for ordinary hours, not including any loadings or penalties, can't fall below the corresponding base rate of pay that would apply to them if they were covered by a modern award. So you do need to review your enterprise agreement pay rates to make sure they're keeping up with the award, and if the award has overtaken them, then that's the rate of pay that should be paid. But also remember, it's relatively common for enterprise agreements to have more generous terms, something that says, for example, you'll be paid a certain percentage above the award at all times. Then you need to obviously do those calculations.
Great. There's a couple of questions here, Simon, that I might just quickly flick through because I think we can deal with them quite quickly. One is somebody asked about the Life Performance Award, and if it's not one of the, correct me if I'm wrong here, Simon, but I'll give my off-the-cuff response to them. So if it's not one of the three industries that are delayed, hospitality, aviation, and tourism, then, and it's not listed there, then it will come into effect on the 1st of July. So in that case, the award would be updated on the 1st of July. Second question is, we know that these rates come into effect on the 1st of July, but when do we actually find out the actual award figures? When does the Fair Work usually release the updated award rates?
Well, great question, and it is something of a bugbear for those of us in this industry. The fact that the announcement gets made so close to the date that the increase comes into effect. If you look at the Fair Work Commission's website and go to the annual wage review page, they have already published what are called draft determinations. So they have a list of the new pay rates that are going to be inserted into each of the awards, but they're still drafts. They are open for people to look at them and point out corrections. So you can go and look at those rates on the website and be, pretty sure that the Fair Work Commission hasn't put a decimal place in the wrong place or whatever. But we usually only get the final determination, the day or two before. But yeah, it's a problem that everyone faces.
Cool, thanks. So there is a draft determination that you can access, which should be pretty close to the money.
Yeah.
Can't see too many reasons why they get it wrong after the decision, but don't take that as advice. Another question, which I think is kind of related to the earlier one about juniors and trainees, is how does the minimum award increase impact people with disabilities on the supported wage system? Again, I think correct me if I'm wrong, Simon, but the answer is probably that if they're on a percentage of the full-time wage, then the percentage will continue to apply, but it'll just be against the new wage. And I think we've also answered the question around the EBA. If somebody, Joanna asked, what if there is a guaranteed increase at 1st of July in an EBA? Well, if that increase is sufficient, i.e. if it's higher than the adult base rate in the award, then it will apply. If your EBA is deficient in its increase and comes in under the award, you'll still need to top it up to at least the award minimum rates. I think that's, there's a question about 38 hours a week. Does it include the unpaid breaks? It needs too complex to answer off the cuff. So we might move to the next topic, and we've got a poll. So we just want to ask after that, how confident are you about which modern award applies to your business, modern award or modern awards? It'd be interesting to just gauge the level of confidence across the group. Well, there's not, sorry, I was going to say there's no answer there that sort of says I'm super confident. So the results may be a little skewed towards less confidence. So, oh, sorry, there is. So I know which modern awards apply to my business. 77% of people on the call, which is great. 16% of people are not confident about award coverage. I suggest you reach out to Simon after this and get some help in understanding coverage of awards for your business. And then 7% of people know that no modern awards apply to their business. I think you'd be surprised at how far and wide the clerical award, for example, can apply, because there are people in every business that you could pretty much argue are covered by the clerical award or the clerk's award. And that has quite a lot of complexity to it as well. So you'd be surprised just how far and wide modern awards do apply. Do you agree with that, Simon?
Yeah, absolutely. But I think 7%. You know, if 80% had said no modern awards apply to our business, we'd really have something to worry about. But 7%, that could well be right.
Cool. All right, moving on.
Okay, so the next topic, which we can deal with fairly quickly, is changes to superannuation, which hopefully everyone is going to be across most of this stuff anyway. The super guarantee rate is increasing from 10% to 10.5% on the 1st of July, and that is part of a planned increase where the rate will go up by 0.5% until it hits on the beginning of each financial year until it hits 12%. The other thing which is happening on the 1st of July is, at the moment, we currently have this rule where if an employee earns less than $450 a month, or on some modern awards, $350 a month, there is no obligation to pay superannuation contributions. That rule is being scrapped. So all employees, no matter what their earnings are going to be entitled to superannuation contributions. The one exception to that is for employees who are under 18 years old. They will only be entitled to super if they work 30 hours per week or more in your business. And then the last point there, just a change to the maximum super caps, so going up from 58,920 to 60,220 per quarter. Those are the maximum earnings that you have to pay super on for an employee in a quarter. So just linked to that, just a very quick word about end of year financial. Hey,
Simon,
yeah.
Sorry, Simon, sorry to cut you off. There's a good question here from an anonymous attendee, which is, do we need to notify our staff of the super changes? If so, can it be a group email? What other notifications? I'm not aware of. Are there notification requirements?
There's nothing. No, there isn't anything specific that says you have to notify the employees. I mean, obviously, you have a duty to give employees pay slips, which will record that the super contributions has changed, but there's no specific obligation to notify them in advance. But a great thing to do if you don't think your employees are across it. But yeah, nothing specific.
Okay, and then another one that Louise has just submitted is a good one too. So, does the maximum contribution super cap, that 60 odd thousand that you mentioned per quarter, can this be reconciled at the end of the financial year and recovered yearly, not quarterly?
Pass.
Right, we'll look into that one. We'll try and have a look.
Apologies.
And look, I know that we've moved on to super, but I feel like I let the ball drop on the award update. So I probably should say to people on the call who are using Employment Hero for payroll or KeyPay, and you have the modern, and you are using one of the modern awards in our platform, updating your wage, your minimum wages is simply a matter of downloading the new rates and rules and updating the system. It's literally a 20-second task to make sure that you're compliant with the new award. And so, yeah, if you are using our platform, a lot of this work will be completely automated for you. Back to end of year financial payroll obligations.
Thanks, Ben. So yeah, just really quickly on this, we've had the introduction of single touch payroll phase 2 in January of this year, and that increases the number of items and the number of things that businesses have to report to the ATO through single touch payroll. And when you have finished doing all your payrolls for this financial year, you need to submit a pay finalisation event to the ATO. That needs to be done by the 14th of July, but a good idea to do it a bit sooner because the ATO's portal gets very clunky towards that end date. And there are some new things that have to be reported on or correctly categorized in your payroll system, which you didn't have to do before. So just make sure that you're across all the details there. Some of the common things that are new are if there have been employees terminated during the financial year, the reason for the termination must be selected. Any employees who are working holiday makers, you need to record their country of origin. There are new income types that have to be recorded. So if any employees are receiving foreign employment income, if they're closely held employees or seasonal workers, that needs to be recorded. And your pay categories need to be correctly mapped. So things like overtime, allowances, leave, bonuses and commissions, all those things need to be recorded before you submit that pay finalisation event. I know Employment Hero did a detailed webinar on this sort of stuff, and also have produced some guidance which we are going to provide a link to after the webinar too. So yeah, just a real snapshot of the obligations, but a lot more help and support out there if you need it. Okay, so let's just move on now to a review of the employment law changes that occurred over the last financial year. And there is, a reasonable amount to get through. So I'll try and take a fairly sort of quick sprint through it. And obviously you can reach out to me if you need further information, and we might have time for questions on this, but just to make sure we get through it all, I'll go fairly quick. So having a look back over the last financial year, in July, there was the introduction of the Wage Theft Act in Victoria, which brings Victoria together with Queensland, the states and territories where deliberate underpayment of entitlements can be a criminal offence now. We had casual employment changes, some fairly significant changes on various different dates, but September was when some of the things kicked in. Those included a new statutory definition of casual employment, which really focused on the date that the employee was first engaged as being the key date for determining whether someone is a casual or a permanent. We're no longer concerned at really what happens after that date. It is what was in the contract, what was in the agreement when the parties first came together, and whether there was an advance commitment to ongoing and a regular pattern of work or not, and that's the sort of the new test. There were double dipping protections introduced, which means that if someone is a casual employee but later found to be a permanent employee, an employer can basically offset the casual loading paid to them against any permanent employment entitlements a casual might claim, such as payment for paid leave, etc. The new protection there for employers, but it does depend on having the relevant clause in your employment contract. We now have this obligation to provide new casual employees with a casual employment information statement, which is much like the Fair Work information statement that has to be provided to all new employees, but this is obviously has a focus on casual employees' rights. And then the last thing, and probably the biggest biggest change with casual employment, is the new casual conversion rights, which give casual employees a right to convert to permanent employment if they've been employed for 12 months and at least the last 6 months of those they are doing a regular pattern of work. There are exceptions to that. They don't need to be converted if there is a reasonable reason not to offer that to them. But we have lots of guidance about that, and we'll share that with you after the webinar too. There was sexual harassment and sexual discrimination reforms introduced in November. It has to be said, fairly limited reforms, a lot more limited than what a lot of people were asking for. But in a nutshell, what the changes were was introducing sexual harassment as a specific a valid ground for dismissing an employee, and also including it within the definition of serious misconduct, which practically speaking makes it easier for an employer to safely dismiss an employee who's been found guilty of sexual harassment. We had the introduction of a new prohibited form of harassment called harassment on the ground of sex, which is all about harassing someone on the grounds of their sex, but not necessarily sexual conduct. So I think we all sort of really understand what harassment, sexual harassment is. So, you know, lewd comments, inappropriate touching, that kind of thing. Harassment on the ground of sex would be conduct which isn't sexual in nature. For example, a comment such as, "This is women's work," or "This is men's work." There's nothing sexual about it, but it is, if used as a form of harassment, it is on the ground of someone's sex, and that is now unlawful. And new powers for the Fair Work Commission to make what are called stop orders, stopping a person, be it an employer or an employee, from acting in a way which is sexual harassment. Also in November, we had the introduction of miscarriage leave, as it was termed, but what this really is an extension of the right to take compassionate leave for when an employee or their partner suffers a miscarriage. So that leave is paid for permanent employees, unpaid for casuals. The next thing in November was super stapling was introduced. So prior to this, there was a system where if an employee joined your business and they didn't nominate a super fund, you could just allocate them to your default fund. We now have a situation where employers have a positive duty to check with the ATO if their new employees have a super fund, and if they do, they have to use that. STP, single touch payroll phase 2, was introduced in January. I won't say any more about that because I think I've covered that earlier in the slides. Then in February, we had some case law about the independent contractor versus employee test. As most people will know, in Australia, we have two forms of how a worker might be engaged, either as an employee when they're working in your business, or an independent contractor where they're working in their own business providing a service to you. Employees have a whole lot more rights and protections. Contractors have a lot fewer. We had some case law in February which altered the test for how you determine whether someone is a contractor or an employee. And really the outcome of that case law was to confirm that what you need to look at is the terms of the contract when the parties are first engaged. What did they agree at the time? There's no longer an obligation to look at what happened afterwards in most cases. It's just what are the terms of the contract that was agreed between the parties. Does that mean you can just give someone a document saying, we agree you're an independent contractor, and they are found to be a contractor? No, it's not as simple as that. What it means is a court, if they were looking at the question, would look through all the terms of the contract and see whether they support the view that someone is a contractor or not. For example, does the contract say that the worker can delegate the performance of work to others? Does it say the worker has to provide their own equipment? Does it say the worker's paid to produce a particular result rather than an hourly wage? All those sorts of factors in a contract are going to support the view that someone's a contractor. But it has to be said, this is a positive case for employers in that it does provide some greater certainty. If you get the terms of your contract right, you can be more assured that you have engaged someone as a genuine contractor. And then lastly, in March, there was the introduction of the Victorian Sick Pay Guarantee, which is an entitlement for certain casual and independent contractors to sick pay funded by the government, paid by the government. It's not something that employers have to pay themselves, but it is a benefit from the government, but a big change for workers in Victoria. So that was a bit of a sprint through the changes of the last financial year. Anything you wanted to jump in on there, Ben?
Well, there's one good question from Kathy Economidis. Apologies for my pronunciation, Kathy. Which was, what about the domestic violence leave that we've heard about the last couple of weeks? Yes, so
I will cover that at the end, if that's okay.
Yeah, sure.
That is something which is on the horizon but hasn't been introduced yet, but we will definitely be coming to that. So yeah, don't worry, we'll cover that. Anything else, Ben?
Not really. There's a whole bunch of questions here which we'll have to come to at the end. So let's get through the remaining slides, and then we can start to dig into these questions.
Yeah. Okay, great. So That's what has happened last financial year. Let's look at what is likely to happen in the next financial year and beyond that. And as Ben said at the start, we've had a change of government. It is inevitable, I think, that there's going to be some major workplace reform. When it happens, what exactly it's going to look like, it's not clear, but we will give our views on some of the changes that might be coming based on announcements by the Labour Party and what other commentators have been saying. But all of this is somewhat up in the air, so it is just going to give you some signposts for what might occur. The other question, of course, is how the Labour Party will get this through Parliament. In the Senate is where they're going to face a challenge. They're either going to need support from the Greens or the Liberals. So what that will mean in terms of what concessions they have to make, we will have to see. But let's just go through some of the possible changes. The first is enterprise bargaining and enterprise agreement reform. It is very likely that what are called zombie agreements will be removed. That is very old enterprise agreements that have terms and conditions which don't keep up with the current modern awards system. At the moment, those things can last forever until someone applies to terminate them. It is likely they will be given a date where they're going to disappear. More powers to force employers to enter into bargaining for enterprise agreements if they are not keen to do so. We think there may be restrictions on employers terminating new enterprise agreements, which have been relatively recently made. A prohibition on small cohort agreements is possible. So at the moment, you only need 2 employees to approve an enterprise agreement. Fast forward a year or two, you might have that agreement applying to hundreds of employees who didn't vote for it. That might be changed. There may be easier rules to make it easier for employees to take protected industrial action in support of an enterprise agreement. When we say industrial action, a strike is the most obvious example that's used. It might be easier for employees to do that lawfully. And there may be a move to make it easier or possible for employees to instigate industry-based bargaining. That is, employees across a whole industry asking for common terms and conditions. That is currently very difficult to do under the Fair Work Act, but there's talk about making that easier. The second thing...
sorry, just on that, I think it's interesting because a lot of the discussion in the media is around, and certainly from the current government, is around the fact that enterprise bargaining has basically come to a complete standstill over the last, 6 or 8 years or something. And they're claiming that it's because there's so much red tape. But 2 observations I think are worth making. One is that the Fair Work Act was drafted by the Labor Party under Julia Gillard when she was the Minister for Workplace Relations. So the red tape was created by the same government that wants to remove the red tape. And all of these provisions, well, other than goodbye zombie agreements, it's introducing more red tape. So I think it'll be really interesting to see. There may be more bargaining, there may be more people covered by bargaining because of the industry-based bargaining, but I don't see any reason that individual employers are going to sort of jump back into the bargaining process unless they're forced to do it. But it's not because they're removing red tape. It's just there isn't, the outcomes from the bargaining process just haven't been flexible enough or worthwhile enough to pursue. So I don't see how that's really going to change under these 6 conditions.
Yeah, I agree with you. I mean, I suppose if the system is changed so that it makes it possible to force an employer's hand into bargaining, that will be how it could be achieved. I mean, at the moment you have an obligation to bargain in good faith. So you do have to, listen to proposals for enterprise agreements, etc. But it is fairly easy, if to comply with those obligations. But those things could become a lot stricter. Timelines could be introduced. I'm not sure. But yeah, I 100% agree with what you're saying.
Yeah. Okay. One to watch.
Yeah, one to watch. Okay, so let's keep going, because I know we're the 3 o'clock is coming around soon. Another big policy objective for the Labour Party is a better deal for women workers. They have said they're going to adopt all the recommendations of the Respect at Work report, which was an independent report into sexual harassment and related matters in the workplace. The big thing in that report, which the Morrison government didn't implement, is this idea of having a positive duty to eliminate sexual harassment and discrimination in the workplace. At the moment, of course, sexual harassment and discrimination is against the law, but the way that the law kind of deals with it is an employer's response to that is really judged when a claim is made, and so it is looked at sort of after the event, if you like. Whereas what is proposed is to have this positive duty, which means that employers are going to have how do we combat sexual harassment and discrimination sort of constantly on the agenda to comply with this duty. So that will be a big change if it is implemented. There are also talks about giving the Fair Work Commission more powers to order pay increases in industries where they are female dominated and are low paid. Another proposal is for employers with more than 250 employees to publicly report on gender pay gaps. At the moment, there is an obligation for employers with 100 or more employees to report on gender pay and the gap between pay for males and females, but it's not public. It is just sort of sent to the government department. The proposal is to make this something that employers have to make public. And related to that, the proposal for a ban on pay secrecy clauses. It's relatively uncommon, I would say, but you do see contracts of employment with a ban on employees discussing their wages with other employees. If that is prohibited, the idea is that will bring gender pay gap issues, into the forefront and into discussions within workplaces. I'll keep going unless you jump in, Ben. But the next area is a focus on job security. There is a proposal that job security should be introduced as an objective into the Fair Work Act. At the moment, the Fair Work Act talks about things like productivity, fairness to low-paid employees, and balancing the rights of employers and employees. Nothing about job security specifically. If that is introduced as an objective into the Fair Work Act, it will mean that all decisions of the Fair Work Commission, be it how a modern award is drafted, be it, is someone being fairly dismissed or not, have to take account of the objective for job security. So that could be a reasonably big change. It is also, I think, very likely that the Labour government will roll back the casual reforms that we've had and that I talked about earlier, so that it is no longer the case that someone who is engaged as a casual but ends up doing regular hours remains a casual. I think they will go back to the way of thinking about casual employment, where someone can be engaged as a casual but they can sort of morph into a permanent employee if they end up doing regular hours. we might well see that. There is talk about limiting the use of fixed-term contracts, so having a ban on a fixed-term contract being rolled over for more than a couple of years, and also talk about having the ability to secure government contracts. So for businesses who do work for the government, not only be able to engage in that work if they have protection for job security in their workplaces, be that a limit on the number of casual employees they employ, or perhaps a limit on the number of labour force or fixed-term contracts that they have. We don't know the details yet, but that is something which could be introduced. Just the last couple of things here. There's been lots of talk about greater protections for workers in the gig economy, particularly what are termed platform workers. So think of, Uber drivers, delivery people, that kind of thing. At the moment, as I said earlier, we have the concept of employee and contractor. Contractors don't get rights such as minimum wages or unfair dismissal. Employees do. There could be a new class of worker that's created that sits in between contractor and employee, and has some more of the rights that we associate with employment that will protect gig economy workers. Case law to date has classified these people as contractors, which means their rights under employment law are limited. So we might see some change there. On a related topic, the Labour Party have a policy, same work, same pay, which is basically aimed at the labour hire industry, I suppose. At the moment, it is possible for a business to use a labour hire provider, that is someone else who employs the staff on their behalf, and pay them less or provide them with less beneficial entitlements than if they were employed by the host employer themselves. That might be because the host employer is subject to an enterprise agreement with higher pay rates, or the labour hire company has an enterprise agreement with lower pay rates. That sort of setup. There is talk about bringing in regulations to make sure that there can't be any difference between whether the host employer employed the employee directly or used a labour hire firm. So something to look out for there as well. Just to finish on what changes we might see in the future, paid family and domestic violence leave, which was raised in one of the questions. This is something which has been provisionally approved by the Fair Work Commission, so not the Labour Party, but the Fair Work Commission, who has power to amend the conditions for award employees. They have made the provisional view that all employees should get 10 days paid, all permanent employees should get 10 days paid family and domestic violence leave. They've made that provisional decision. It's not clear when that's going to come into effect, but they have indicated to the government that before they make any decisions, they'd like to hear what the government's view is. So it may well be that the government will say, well, we want to see that introduced for non-award employees at all. They might mirror what the Fair Work Commission has proposed, or they could provide something more generous. They could say casual employees get that leave, paid leave too. We're not sure, but we will. It is before the Fair Work Commission at the moment, so I expect we will hear more about that in the next few weeks. So that's definitely going to happen, but exactly who it applies to, exactly what it looks like, it's not clear. And then just finally, there are some fairly significant changes coming to individual awards. The Social and Community Services Award has had a real refresh and some new conditions which will be introduced from the 1st of July. We've done lots of work on that, so reach out if you need any guidance on that. And then the Hospo and Restaurant Awards, some fairly significant changes to how annual salaries are paid to employees under those awards coming into effect in September. Ben.
All right, that's your last content slide? Okay, so while we're just reviewing the 28 questions in the Q&A box, we'll start this poll. Which of these reforms will have the biggest impact on your business? Changes to enterprise bargaining and enterprise agreements, better deal for women workers, focus on job security, reform to casual and fixed term employment, or gig economy labour hire reform. Please submit your answer so that we've got some more information and we can get to answering these questions. So, Simon, we might just go through them quickly from the top down. We've got 7 minutes. So is it okay to backdate increases, including the remuneration, which including in the REM review, which is run in August but backdated? So 1st July, I think you need to apply the new minimum wages from the 1st of July or the first pay period ending after the 1st of July. If you are paying less than the award minimums between the first pay period after the 1st of July and whenever you choose to backdate, you would be technically in breach of the award. Is that correct?
Yeah, 100%.
Cool. Sorry, just coming back to the poll. So the answers, the one that's going to have the biggest impact, 51% of people think that a focus on job security, reform to casual and fixed term employment will have the biggest impact, followed by a better deal for women workers, changes to enterprise bargaining, and only 6% of people being affected by the gig economy and labour hire reforms. Cool, I'll close that and keep coming back to these questions. So can the super increase be absorbed by our employees' current salaries? I think technically, yes. Again, Simon, correct me, but if people are being paid above award and then there's a 0.5% increase to super, the employer has to pay that. You can't reduce the salary, but you're just paying more super. You're just maybe not you're absorbing it into the next wage increase.
Yeah, I expect what they're saying is if you've expressed to your employees you're paid 150k inclusive of super, if the super rate goes up, can you keep that 150k package, which in essence would mean the base salary is going down as the super rate goes up, but they're being paid the same overall? I think the answer to that is it really depends on how the contract is drafted, and it is something that you would probably want to get some advice on, but some professional advice. But there are mechanisms where that is probably going to be possible.
Yeah, I think that's got to be considered in the context of the fact that we have record inflation. There's going to be expectations of wage increases across the board just to maintain real earnings. So super is just one other consideration to factor in. The next question, Simon, is with the removal of the super minimum amounts for casuals and hours and etc., does this effectively mean that all casuals will now receive a super contribution? I think the answer is basically, yeah.
Yeah, basically, yes. The only exception, as I said, is for under 18s, then they need to be working at least 30 hours a week. But if you employ a casual for a one-off Saturday and you never hear from them again, if they're 18 or over, yes, they need to be paid super.
Yep. Will Employment Hero automatically calculate the cap removal, i.e. under 18s, 30 hours a week? I imagine it will automatically update the 10.5% super. Yeah, we'll update the 10.5% super. Good question around under 18s and 30 hours. I'll have to clarify. We'll get back to you on that one. Do we have to notify all employees of the increase to the award in writing? I think we already answered that.
I think that was super.
What about the award increase? I mean, you have to provide employees with access to a copy of the award.
Yeah.
But I don't think you need to specifically notify about the increase to the salary or the minimum wage.
Yeah, I agree. The only things in the award which are similar to that is notifying an employee when their classification changes, but notifying them about an increase in the minimum wage, no, I don't think so. Obviously, if that affects the wages they are being paid, they will see that in their payslip, but I don't think you need to notify them in advance. But again, great if you can do that, if it's going to affect them. Of course, that would be a best practice approach.
Yep. Okay, we've only got time for one or two more. So we have a fortnightly payroll. That's going to be too specific to Joe. There's a few here that are quite specific. What if an employee? Oh, have you got one there? Go for it.
Just one about miscarriage leave. How many days is paid miscarriage leave? Is it just the 2 days of compassionate leave? Yeah, exactly. Compassionate leave prior to this change was 2 days per event where someone in your immediate, or someone in an employee's immediate family or household was either had a life-threatening illness or injury or died, and you got 2 paid days of leave per event for a permanent employee. What's happened is miscarriage has been added to the list of things, so it now says you can take compassionate leave for where a member of your immediate family or household has a life-threatening illness or injury, has died, or if the employee or their partner has suffered a miscarriage. So yeah, 2 days added to the list of things you can take it for.
Great. Thanks very much. So look, we've run out of time for Q&A, but we'll go through those remaining questions and attempt to provide a summary of the major Q&A points when we share with you a copy of this webinar. I just want to say thank you to everyone for joining us. You'll receive a survey automatically after we finish this. Please give us feedback. We'd love to continue improving the content and style of presentation. So your feedback is definitely wanted. Simon, thank you very much for giving us your time. You're a fountain of knowledge, and I encourage anyone on this call with specific questions to please reach out to Simon and his team for specific advice. And if you're not using Employment Hero, then a lot of these issues will be automated if you're using our platform. Award updates, superannuation, minimum contribution increases, I presume the minimum of 30 hours and things for casuals and eligibility for super will be automated again there. So a lot we can do for you, as well as our policies, contracts, and other content in the platform will all be kept up to date in line with these legislative changes as well. And Simon helps with all of that. So again, thank you, Simon, for being on the webinar and for keeping our clients up to date with their obligations. Happy end of financial year to everybody, and I hope you have a great afternoon. Thank you.
Thanks, everyone. Thanks, Ben.